5 seconds to go. Start. The appellant was found guilty of offence under section 302 IPC and was sentenced to death by the Sessions Judge Kamrup, Guwahati in SC number 114K of 1996 on 18th August 1997, which was confirmed by the Division Bench of the Guwahati High Court in Criminal Death Reference number 2 of 1997 and Criminal Appeal number 254J of 1997 on 3rd February 1998. Against the judgment of the High Court, the appeal is filed by special leave. This court admitted the appeal limited to the question of sentence. The gravamen of the charge against the appellant is that in the morning hours around 7 am on April 24, 1996, Hara Kanta Das was taking his morning cup of tea on the corner tea stall of MG Road and Chamber Road, Guwahati, along with others. The appellant arrived at the scene with a sword-like weapon and with it dealt blows to Hara Kanta Das, who fell down on the ground. The appellant amputated the right hand and thereafter severed the head of Hara Kanta Das, the deceased. With the head of the deceased in one hand and the blood dripping weapon in the other hand, he moved majestically towards Fancy Bazaar police outpost. The occurrence was witnessed by persons standing there, of whom PW3, PW5 and PW8 were examined as eyewitnesses. PW1, the sweeper, rushed to the police station to inform about the incident. There he found the appellant entering into the police outpost. PW2 was on duty. The appellant asked PW2 where he should keep the head and the weapon and placed them in the veranda of the police station. The weapon was seized and marked as Exhibit 1 after conducting inquest over the head. After taking the head to the scene of occurrence where the body was lying, another inquest was conducted and the body was sent to the doctors for conducting post-mortem examination. PW9 conducted the post-mortem examination and sent report Exhibit 14. PW9 noted that the head of the deceased was severed from the body, which was having as many as 9 injuries on it. The learned Sessions Judge Kamrup, Guwahati, having considered the evidence of eyewitnesses, which was corroborated by the medical evidence, found the appellant guilty of offence under section 302 IPC. On the question of sentence, the learned Sessions Judge gave an opportunity to the appellant to state the mitigating circumstances, if any, and noted that he did not state anything relevant and that he even refused to put his signatures on his statement. The learned Sessions Judge mentioned that the appellant remained uncooperative on being asked further questions in regard to sentence. In the circumstances of the case, having applied the principles laid down by this court, the learned Sessions Judge concluded that it is rarest of the rare case and accordingly sentenced the appellant to death and referred the case to the High Court under Section 366(1) CRPC for confirmation of the death sentence. The reference was numbered as Criminal Death Reference number 2 of 1997. Against his conviction and sentence, the appellant filed Criminal Appeal number 254J of 1997 in the High Court of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh at Guwahati. That appeal and Criminal Death Reference number 2 of 1997 were heard together. After elaborate consideration of all the facts and law, the High Court confirmed the conviction and sentence of death passed by the learned Sessions Judge by its judgment dated February 3, 1998, referred to above. Mr. Goswami, learned senior counsel appearing for the appellant, submitted that the appellant was not properly represented before the trial court as well as the High Court at the material time. He is a young man of 33 years and having 3 unmarried sisters and aged parents. He was also not well at the time of occurrence. The case has also not been investigated properly, and there is no material to show that he has become menace to the society. He prayed that the death sentence may be commuted to life imprisonment. Mr. Sunil Jain, learned counsel appearing for the state, contended that the cruel manner in which the crime is committed did not admit of any leniency. The deceased came predetermined, duly armed with sword, and targeted the deceased among the crowd of persons standing there, while the deceased was unarmed and was taking his morning tea, and that it is a fit case to confirm the death sentence. The exercise of power to award death sentence is now circumscribed by Section 354(3) CRPC. The said subsection provides that when the conviction is for an offence punishable with death or in the alternative with imprisonment for life or imprisonment for a term of years, the judgment shall state the reasons for the sentence awarded, and in the case of sentence of death, the special reasons for such sentence. Stop.